now it's time to dive into our first substantive topic, and that's actually me. What a coincidence. We're talking about new laws and regulations. This is part one. We have a lot of new laws, so we decided to divide it up amongst really four of us. That's how many we have. But this isn't really like the deepest dive. This is, I would say, more issue spotting so that you understand that there's something out there that you may need to know about. And of course, you can feel free to follow up with us anytime if you have deeper questions. So let's start, shall we? First of all, just want to let you know about, really, this is what we have to say every year, but there are minimum wage increases. And this year in California, it's now $16 an hour. So not only do you have to make sure that you're paying your non-exempt employees that amount, really, this is quite relevant if you have exempt employees, because as many of you know, there's something called the salary basis test in order to pay an employee a fixed annual salary. And so the magic number that everybody needs to know now is this one, $66,560. So what that means is you are paying pretty much any employee in California a salary, and you're paying them less than that. And I find that from time to time, some employers just aren't really thinking about that. You are likely out of compliance with that individual, and they will lose that exemption. So, I mean, of course, there's other parts of the test, but that's the low-hanging fruit. So that's a number that you really do need to know. And then just don't forget that there are a number of cities in LA and counties that have their own minimum wage. And as you see from the slides, many of those did go up this year as well. West Hollywood now wins the award for the nation's highest minimum wage. It's a bit over $19 an hour. So I guess that tied with the relatively new Hollywood sick leave ordinance, which is a doozy. Let me tell you, if anybody has any employees in West Hollywood, then you know what I'm talking about and you feel the pain. And if you have employees in West Hollywood and you don't know what I'm talking about, then you really need to talk to us because we've got a few things to share with you, unfortunately. And I mean, just for, it's probably relevant for us, the city of Los Angeles is now 1727. Sometimes I get a question from clients, well, if we have an employee in Los Angeles, does that mean we have to pay them twice the minimum wage for an exempt employee? If their minimum wage rate is higher in a city, the answer is no, right? For the salary basis test in California, it's only, fortunately, the state minimum wage we look at, which is why that 66,000 number is the right one. Okay, I'm not going to spend too much time on this one because I don't think it's going to come up very much, but I did want to let you know, again, in the vein of employee-friendly laws, we have expanded workplace defamation privilege that's now enacted with AB 933. It adds a new section to the Civil Code. And what it does is that it expands privileged speech to expressly include communications, whether oral or written, regarding factual information pertaining to sexual assault, harassment, or discrimination. And so what this just really means is that if a person who's making a statement about that, so long as they had a reasonable basis to file a complaint about that, say in court, and it's without malice, right, then really the statement cannot form the basis of a defamation claim. And so how would this come up? Well, let's say an employee is speaking about to the press or to others really about the fact that they were sexually assaulted at work or they were subjected to discrimination, and then say a manager or a employer wants to file a lawsuit for defamation against them, basically saying that that was false and untrue, they're going to have a very tough time doing that, given this law, to the extent they were considering that. And then just this last point here, now keep in mind that in a case like this, the defendant would be the employee here, right? Because they would be suing. Because the employer or the manager would be suing them, right? So the employee would be the defendant. And so, of course, that's why unusually here, the defendant can recover attorney's fees, treble damages, punitive damages. And so that's further disincentive for someone to think about filing a defamation lawsuit against an employee for speaking up. Okay. Updated California wage theft notice. So there is a notice that needs to be provided, as some of you, hopefully all of you may know, to non-exempt employees, not to exempt employees. And fortunately, I'll let you know there really aren't that many penalties that are associated with failing to provide this notice, but nonetheless, we highly recommend and encourage everybody to comply with this law. Of course, you can choose to have your own notice in some other written form. You don't have to use the notice template that's provided by the Labor Commissioner. Most people do the latter, but the latter being the notice that's provided. And that was updated to account for a new law, which basically says that for every new employee, you have to state if there's any natural disasters or federal or state emergencies or disasters declarations that were applicable 30 days prior to when the employee started. And there's now a new area of that notice that the Labor Commissioner has updated. And in case you're wondering, well, how do I know what all of these disasters are? And do I have to go, because it's for every county where the employee works. So you've got homework to do now for employees. Fortunately, I did some research and I found a website in California that lists all of these declarations, and a similar website for federal government where it filters down to California. So you just really need to check those two websites and you'll find what you're looking for. I think the Labor Commissioner went a bit beyond the law, because there's a space where you have to state how these affect the health and safety of employees. And the law does not state that you have to describe how you do it, but they ask that you do it. So it'll be interesting to see how this pans out, but please be aware of that update. Very briefly, look, we're not done with COVID yet, but certainly things are a little bit more relaxed. And so we talked about this last year, actually, because the regulations were already out. They were not in effect. But we now have non-emergency temporary standards for Cal-OSHA concerning COVID. And I call them NETs. I just made that up, but it seems easier to say than that whole long phrase. And I just wanted to remind everybody or bring to your attention that there are COVID model prevention procedures that every employer has to have. But the good news is there's a fillable form template available on Cal-OSHA's website. You do still have to make testing available to employees at no cost and during paid working time. If there's a close contact, et cetera, you still have to exclude employees from the workplace until they no longer pose an infection risk. You still have to provide and require masks under certain situations. You still have to notify employees under the labor code if there is a COVID case in the workplace and they may be a close contact. And you do have to report major outbreaks to Cal-OSHA if you have them, as it's defined under the law.